So disputing coerced debt on a credit report. All of this will be governed by the FCRA or FCRA. So if you hear me say FCRA, Fair Credit Reporting Act, that's what I'm talking about. It is all found in 15 USC 1681, and it is broadly defined as far as what a consumer report is and what a consumer reporting agency is. But a consumer report is broadly defined to be, any information that relates to a consumer's creditworthiness, character, general reputation, and so it's pretty broad. But in order for it to be a consumer report, it has to be something that is compiled and sold using interstate commerce by a consumer reporting agency. And so a consumer reporting agency, again, is also kind of broadly defined. But as I had mentioned earlier, there's the list of the CFPB of consumer reporting agencies that it regulates. And so if you're concerned whether or not it's a CRA, don't be, if it's Experian, TransUnion, or Equifax, then you don't have to be worried because those are consumer reporting agencies, they're CRAs. And so this law mandates what can be included in the consumer report. So, what kinds of accounts, how long that information can be on a credit report. So, if it's a negative account, it has to fall off after 7.5 years. So it talks about that. Who can access the report? These are the users, like who can look at my report, who is allowed to look at it. When the consumer has a right to get a free report, and then their right to dispute any information that's inaccurate to have it corrected. So the Consumer Reporting Agency has this basic duty to make sure that it has policies and procedures in place to assure maximum possible accuracy of the information that it compiles for an individual consumer. So that means, they can't just put anybody's information on my report. They have to have policies in place to make sure, reasonable procedures to make sure that they all actually do pertain to me. So they should match my date of birth, my social, my address, all of that information to verify that that account really is me and belongs to me and should be on my report. Who can access reports? Consumers have a right to access this report. Third parties or users can access them, but only if they have a permissible purpose. That's found in 15 USC 1681B. Some examples of permissible purpose are on the next slide, but generally, I talked about those promotional account review inquiries. So they have the ability to access my report. Anyone I give permission. So if I apply for credit and check, giving them permission to pull my report, they would have access to it. And the access to that report is called an inquiry, a pull, or access. We already talked about the different types of inquiries as well. So these are more examples of permissible purposes, and you see them here. So now all of that is kind of background on the FCRA, what it does, what it regulates. It's a really broad, but I'm going to go through now specifically the remedies that are and the rights that the FCRA provides for ID theft victims. So the first is the block, and I'll be spending some time talking about that. Then there's security freeze, which I'll spend some time talking about that. And then there's fraud alerts. There's an initial and extended. I won't be spending a ton of time on these because I frankly find these not helpful at all, but I will at least tell you what they are. Most of these protections, the block, the security freeze, and the fraud alert, most of them require an identity theft report, which I'll define in a couple of slides. But if you don't have an identity theft report, you can still request a freeze, and you can also dispute the information and request a deletion, which I'll get through later as well. So there's some things that a coerced debt survivor can do, even if they don't have an identity theft report. So what is an actual identity theft report? It is defined here under 1681A Q4, and generally it is a report that is filed with law enforcement or whoever the Bureau, being the CFPB, designates. So generally that that is law enforcement is police report. So your local law enforcement, whether it's your county, your sheriff, your, police department of a city. It can also be the Federal Trade Commissions. They have an identity theft report at idtheft.gov that you can file, and they're a law enforcement agency, so that would qualify. If the theft, identity theft was done through the mail, then the U.S. Postal Inspection Service report would qualify. And then FBI, if it was done through the internet, you can do an FBI crime report. That's ic3.gov. And then now these other documentations aren't generally an identity theft report, but they may be helpful to prove that the person was an ID theft victim. And that would be a protection order, so PO, judgment of divorce, or even a 521 ID theft order, which is what we are trying to achieve through this pro bono program. So as I mentioned before, the reason I talked about the dates about, if this debt was incurred before 2019 or after 2019, but before 2021 or after 2021, is because what you may be able to obtain. So if it was done, as you see here in this graph that we'll make available to you, if it fits within this bucket of fraud, right? They never knew about the debt, they didn't consent to it, by signing or anything like that, then they will be able to obtain, any of the, like a police report. You can file a police report for that. You can do for ID theft. You can do an FTC report. And then again, if it's credit card or debit card abuse specifically, then yes, you can get that. If it was through the mail, then you can get that USPIS ID theft report. So again, if it fits within the ID theft traditional bucket that everyone thinks about, you have all of these remedies available. The reason there's a maybe there is because it depends on whether the account was credit or debit or whether it was done through the mail. Now, if the victim had knowledge, but was coerced, so again, within the second bucket of the threat of harm, force, manipulation, if that was prior to 2019, you will not be able to get any of these reports, the FTC ID theft or the police report, because it didn't meet the definition of identity theft at that time. The laws are not retroactive, so it's as of 2019. So no police report, no ID theft report. However, if it was if it was a credit or debit card, it would meet the definition of credit or debit card abuse because of that effective consent was in that definition prior to 2019. So you'd be able to get a police report for that. And then again, it depends on whether or not the USPIS, if the mail was used. If the victim had knowledge but was coerced to take the debt after September 1, 2019, then they can get the FTC report. They can get the police report. And then again, the maybe on the police report for credit or debit card abuse or the USPIS is the same as, the first one. Depends on if it's that type of account and if it was obtained in that method. So identity theft report, again, you need that to get certain relief under the FCRA. And in order to get the identity theft report, you have to be an identity theft victim. And so if it was obtained, from 2019 until today, you can get a police report for it here in Texas if it was obtained through coercion or fraud. If it was just obtained through coercion, you can also get that report if it was done after 2019. And then you can use that to dispute the debt, to request the block, to do all of the things that we're going to talk about now. So a block is essentially a tool that the consumer reporting agencies have to prevent any information that resulted from identity theft from appearing on a consumer report, so on the survivor's credit report. So let's say, for example, that I have 10 accounts that are all the result of identity theft, and they're all on my credit report. I can say, hey, Equifax, here's a copy of my police report showing that I'm a victim of identity theft. here are all the 10 accounts that were from identity theft. I am requesting you to block that information from appearing on my report. And so they have 4 days from the receipt of notice to make sure, to basically check that my request has all the things that it needs, which is right here on this slide. And then they have to block that information. There's only a couple of reasons they can refuse that block, which are also at the bottom. And so if they do that, then the next time I get my credit report, whether it's in that week or 30 days or whatever, those 10 accounts cannot be on my report because they've been blocked from appearing on my report. Now, technically, they may still be in my file. There's a distinction between a credit file and a credit report. The credit file is all of my information for my entire, for as long as they've had information about me. So if they started gathering information about me when I started getting accounts at 18, then they will have all that information in my file, but it may not all appear on my report. And there's, as I mentioned before, there may be accounts that are too old to appear on there, and so it can't be on my report, but it's still in my file. Or even things like this where I request them to be blocked, so they can't be on my report, but they'd still be in my file. Later on, I'll talk about the other, mechanism to dispute and request that they be deleted. And if you do that, then they do have to be removed from both your report and your file, but that's just a separate provision. That takes longer. It's, it's 30 days to investigate. They have to let the furnisher, which is either the creditor or bank, know. They have to investigate as well. And so the block is quicker. It is, within 5 days, 4 business days, but it's 5 days. And so that is generally kind of the better option if time is of the essence for the survivor. And you can always do both. You can request the block and the deletion. Again, one would come quicker and the other one would take more time to get the final resolution. But you can do both. And so for a request to block, it has to have certain information in it. It has to have proof of your identity. It has to have a copy of an identity theft report. So again, that police report, the FTC identity theft report. And it has to identify the information that you're requesting to get blocked. So whether that's phone numbers, inquiries, addresses, names, accounts, or even just charges on an account. So the whole account is not fraudulent, but there are some charges that are. And then a statement by the consumer that the information is not related to the consumer. So that's, that would be checked. If you say, I'm a victim of identity theft, I didn't, take out any of this, I didn't take out these accounts, I didn't use this account, or, anything like that. This is not related to me. It shouldn't be on my report. It's not me. Now, they can only refuse to block that information if the request was made in error, or it was based on a material misrepresentation by the consumer, so the consumer lied, or if the consumer was the recipient of funds, goods, or services of the block transaction. So that's kind of tricky, because if some of this was based on, for example, a coerced auto loan that you're requesting to be blocked, but the consumer, the survivor, actually has possession of the auto and is driving it, then the CRA can refuse to block it because they did receive those goods. So it's the same if it was like a credit card and it was used to purchase a TV and the consumer has possession of the TV. So again, this is more, the list of information that you can put in the letter requesting the block is, accounts, the charges, the addresses. I already stated this before, but it's written here, so you can check it off when you are looking through your, what to put in the letter, what to include. And then most importantly, what I haven't yet covered is the very last thing on this slide, a request to receive an updated copy of the report. So once you send in the letter requesting the block, and they have that 4 business days to put the block on, they also have to notify the consumer afterwards that they have blocked it or that they refuse to block it. And so at that point, if you've requested a copy of an updated report, they will also send you a copy of that. And And you also, in addition to what you include in the notice, in the actual letter, you have to include other documents. So these are the documents you include with the letter. That photo ID that's state issued, or that proves their identity, and with their current address, if it's not their current address, and any other document showing a current address, that ID theft report and the police report. It's sufficient, it should be sufficient to just have one. In practice, I have found that sometimes you need both. So I put both the police report and the FTC identity theft report. Include a copy of the credit report with the highlighted or circled disputed and inaccurate information. Even though you already listed it in the letter, I don't know why, but they just don't have the best procedures, which is why they often get sued. And so I try to make it as foolproof as possible. Like, I put this in my letter, but also I included it in the report, and here's all the information. You want to send it by certified mail, return receipt requested. And that is because you want proof that they obtained it, that they received it. And also, so you know the date of when they received it, so you can count how many days from when they received it to them blocking that information and responding to the survivor. So that was the block. I will go through security freeze. I'm going to actually skip to that slide, and then I'll come back to the dispute process. So a security freeze is free. It doesn't cost anything, and you don't have to submit an identity theft report. That law was recently changed. It used to be that either you had to submit a police report or pay a certain amount, but now that changed after there was a huge Equifax breach. So now anyone can request this. You can do it over the phone, or you can do it in writing. My recommendation is, if you need it quick, the survivor needs it quick, do it over the phone, and then follow up in writing with either the request to block, or the dispute letter, disputing it, or, if you're doing all of the things, and put it in that letter. What does it do? What does it actually do? So it is exactly what it says. It freezes. It prevents anybody from getting access to that survivor's credit report. And why this is really crucial and important is because if your client does not need to take out any new credit, this will prevent any new credit from being obtained without them knowing. So if the abuser is trying to take out new credit, it will stop that, because that, let's say he's applying for a credit card, or he's applying for an auto loan, and they try to pull the report, there's going to be a freeze. They can't access it. And it cannot be lifted unless the survivor calls and requests the lift, and they have to provide a PIN, which is given to them after they get the freeze. That's the only way to lift it. It does not prevent the survivor themselves from being able to access the report. So, and it does not prevent anybody who already has existing accounts, so those like account review inquiries that I mentioned before, they can still look at it. Certain government entities, so child support, so they can use that. And also, if you're applying for housing or employment, they'd still be able to obtain that information. But as a best practice, I always tell the survivor, if you know you're going to either apply for a job or for housing, or even if you're going to apply for credit, go ahead and lift that freeze just for that amount of time. So you can lift the freeze for, like 30 days or 3 days, or you can even lift it for just a particular creditor. So if you know you're going to apply for, credit with Chase, you can just lift it to Chase. So these are the practice tips. Again, you can request it by phone, mail, or website. So these are the websites. I generally try to steer people away from the website because of arbitration clauses that I don't, want them to be bound by if something goes wrong. So I think by mail or by phone is the best way. If they do it by phone or, again, online, the freeze has to be placed 1 business day. By mail, then 3 business days. Once they obtain confirmation of the freeze, which they have to get afterwards, it will have that information in that letter on how to remove it or to lift it, the PIN that they need, and all of that has to be given within 5 business days after they receive the request to freeze. So I mentioned this already. it can be removed permanently or temporarily. It's called lifting or thawing. And so here's kind of how you do it. You can do it the same way by phone, it's the quickest. And so once they have it by their pen and that letter, then they just pick up the phone, and it has to be done within an hour. And then if it's done by mail through a letter, then 3 business days. So I am now going to go back to the disputing process before talking about the fraud alerts. So we talked about the block. The block is only for ID theft. The freeze is for anybody. The fraud alerts are only for ID theft, but again, I'll cover those later because I don't think they're that important. But then the dispute process is for everybody. So you don't have to be a victim of identity theft, but certainly if you are a victim of identity theft, you can still use this process. So as I mentioned before, this is where it takes a little bit longer time. It takes 30 days. And they do what's called a reinvestigation. Even though it's the first time they're investigating it, it's still called reinvestigation. So you send this dispute to the CRAs. You say, hey, Experian, hey, TransUnion, I am disputing any inaccurate information on my report. So for a coerced debt victim, the reason would be identity theft, right? You're saying this shouldn't be on there because it doesn't belong to me because I'm a victim of identity theft. And you put all of the information, that is as a result of identity theft on there that you're disputing. But if there's other inaccurate information, just so you know that other people can dispute, it's like, hey, this account says that I was late. I was never late on those payments. Or, hey, this account is, showing that it is a joint account, but it's actually just an individual account. Or, hey, this account is 7.5 years old and it should not be on my report anymore. Or, hey, whatever is the inaccuracy, or, hey, this shows that I was that I'm, owe $2,000, but I only owe $1,000, whatever it may be, any inaccuracy you can dispute. So what happens here, which is a little different than with the block, here the CRA has to send notice to the furnisher, and the furnisher has to investigate, and then the furnisher tells the CRA what to do. So they'll say, yep, this information is accurate, confirm. So it'll be, the result will be verify. Or they'll say, oh, wait, you're right. This information is not right. Update it. So if it was an account that still should be on there, but it was an amount that shouldn't be there, or charges that shouldn't be there, then they'll update it to reflect the accurate information. If the whole thing shouldn't be on there because the whole thing is identity theft, then they will tell the CRA, hey, delete this information. So they will tell them verify, update, or delete. That will be the response to the investigation. The CRA technically has discretion to themselves because they're also supposed to do an investigation. So they could very well say, yeah, we agree with you. It's identity theft. Let's delete it. But the way that it works, they actually rely or they parrot whatever the furnisher says. So for that reason, I always, the furnisher is supposed to get everything that you send to the consumer reporting agency. Sometimes it doesn't work out as cleanly. So I always best practice send the dispute letter that you're sending to the CRA, Experian, Equifax, TransUnion, also to the debt collector. So you want to, or the creditor, whoever's furnishing that information. So if it's a Chase, you do Chase. If it is LVMV, you do LVMV. Send it to both by certified mail. So once they get that, once the consumer reporting agency gets that dispute, they will send it out, and then they will wait on the results, and then they will, all of this is supposed to take 30 days, and then they will respond to the survivor with the results. The results have to be in writing, not later than 5 business days after that. They say the reinvestigation was completed. They give you a copy of the revised consumer report if you request it. If not, they'll just give you snapshots of what they did. And then, depending on what the outcomes are, they have to say the consumer has the right to add a statement to their file disputing the accuracy or completeness of the information. So, again, it will either say verify, update, delete, and you'll note that. So what do you actually include in a dispute letter? Similar to the request for block, you include all of the information that you're disputing that's inaccurate, and asking for it to be removed or updated and why. So again, you see here, counts shouldn't be on there because of identity theft. Coerced debt is the term that we're using, but they don't, the consumer reporting agencies don't recognize that. So you'd want to explain that it's identity theft. The charges that the survivor didn't make, that don't belong to them. The addresses, the phone numbers, inquiries that don't belong to survivor, all of those things are what you're going to dispute. So again, you explain why it's inaccurate, and then you ask for a copy of the updated report. And then again, with the letter, similar to the block, you want to request, you want to include, the report with all of the information that you're disputing, highlighted, circled. You can also, provide a copy of, you don't have to provide an identity theft report like you did with the block, but if you have it, I would include it as well, to show that you are a victim of identity theft, if that's the reason we're disputing it. You can also include other requests, right? You can include, hey, block this. And so if you're going to request a block, you have to include the identity theft report. Block this. I'm also disputing it. And also I want a security freeze or fraud alert if you want them. And then again, best practice, certified mail return receipt requested. So now that I talked about that, now I'll talk about fraud alerts and why I think that they're not very helpful. A short-term fraud alert is free, and you don't actually have to submit an identity theft report. It lasts for a year, and then after that you can review it. You can renew it every year. But essentially, what it does is that it says, for any, like, when a credit report is pulled for a survivor, there's like a little note on there that says, hey, you want to make sure that, the person who is applying is actually the consumer, take reasonable steps to verify their identity. And it says they may contact the survivor if they provide a phone number, but they don't have to. And so it is super wishy-washy. Like there's just like, hey, try to make sure you do this, try to make sure you do that, but there's no, you must do this. And then there's an exception for it as well, which is that it doesn't apply if they're obtaining a new credit card, because it exempts what's called open-end credit. So any credit card, this wouldn't apply. When they pull it up, none of that would show up. Or if it's an existing credit line, and you're asking for an increase or adding an authorized user and asking for a new credit card, this won't show up either. And because a lot of coerced debt happens with with credit cards, then it's essentially pointless at really helping prevent new credit card debt and new coerced debt in that form. So that's why I'm just going to skip through it because I don't think it's that important. The extended fraud alert is a little bit better, but not by much. It is 7 years, and it is, for this one, you do have to submit the identity theft report. The only difference here is that it says that the CRA has to provide the survivor's phone number or reasonable contact method that was designated by the consumer. And the creditors have to contact that person in that contact method. So this can be helpful if the survivor actually says, hey, here's my phone number or email or whatever I want them to contact me at. And then the creditors are supposed to do that. But again, the exception is those credit cards, new credit cards, existing credit card with either an increase or an authorized user. So again, because so much of it is through credit card debt, this really won't prevent that. So don't think it's super helpful, but the information on how to request that is all in here. So again, that was a lot of information. We're just going to review it real quick. So if the survivor is the victim of coerced debt, they can request a block as a victim of identity theft. They can dispute the information. They can request a security freeze or any type of fraud alert. In one letter or in separate letters, And again, it will depend on if they are able to get a copy of that police report or identity theft report based on when the coerced debt happened. If it was post 2019, they'll be good. If it was pre 2019, they may not be able to request the block, but they can dispute it and get a security freeze. You want to send these letters by certified mail, return receipt requested, and include all of the attachments, the identity theft report, a copy of the report with it circled, a proof of identity, all of those things. And last but not least is the letter should be written in the voice of the survivor. So you're not, you don't write it saying, hi, I'm, Carla Sanchez Adams, I represent Jane Doe, and I am disputing this on her behalf. That won't work. It has to be the survivor who disputes it. And you want it, in their voice. And I have in here, you may need to use a translator certificate. So, I had clients that didn't speak Spanish. That didn't speak English, only spoke Spanish. And so, I would there at the bottom say, I'd write it in their name. And, again, Jane Doe, write it, sign Jane Doe, and then at the bottom put, this document was translated to me. And, we have an example of a translator certificate, write my name, say, they don't read or write English, they speak this language. I would translate it for them into English and have my signature. The return address as well should not be your firm, it should not be your address, but it should be the address of the survivor. They will receive all correspondence. So all of the letters with the results of the investigation or the results of the block, the updated reports, all of that will be received by them. So you will need to tell them to make sure to look out for those letters, those documents, and then to bring them to you or to email them to you or to fax them to you. There are some applications, phone applications. One is called Scannable, where you can take pictures of the document. It turns it into a PDF that you can then text or send by text or send by email. And you also want to advise your client that whatever address they receive will, the mail at, the correspondence at, will become a part of their file and appear on their report. So you want to make sure it's a safe address. Always, always request an updated copy of the report. And then again, if the dispute doesn't work, especially after obtaining a 521, refer the survivor to a consumer attorney, contact TAP again. So again, one more review before we go on to disputing it through debt collection piece is this is the mechanisms, right? We just talked about the negative credit reporting and the options here under the Fair Credit Reporting Act, right? The security or credit freeze, short-term extended fraud alerts, the block and the dispute, all of those things is dealing with the negative credit reporting piece. What we'll go into in the next section is debt collection efforts. So, how to dispute with credit card debt, how to contact debt collectors, the 521s, and then we'll briefly talk about debit and bank accounts and how to dispute money that's been taken through the survivor's bank account under the Electronic Funds Transfer Act.